Memorandum of Association. What is Memorandum of Association? What is memorandum? First, let's see the meaning of memorandum. Memorandum is the constitution of the company. It is the charter of the company. It provides foundation on which structure of company is built. It defines the scope of activities of company. Okay, the scope of its relation with outside world. Okay, it defines the limits of its power, the extent and ambit. Nothing shall be done beyond that power. Okay, it defines the ambit or the scope or the extent or the limits of the activities or the powers of the company. If anything is done beyond this limit, it is not allowed, it is void. Okay, nothing shall be done beyond that power. The definition of memorandum of association or memorandum is given in section 2 clause 56. It is said that memorandum means memorandum of association as originally formed or altered from time to time in pursuance of any previous company law or this act. Okay, memorandum means memorandum of association as originally formed or altered from time to time in pursuance of any previous company law or this act. What is the purpose of memorandum or memorandum of association? Suppose the prospective shareholders can contemplate risk involved in their investment by knowing the field in which the company will use their fund, the purpose of the company. Okay, in the memorandum, the field in which the company will work or the type of business the company will work, it is given in the memorandum. The purpose of the company is given in the memorandum. So if there is a prospective shareholder who wants to invest in the company, he can contemplate its risk, okay, by knowing that in which type of field the company will use his funds or what is the purpose of the company. So it will help the shareholder. The outsiders dealing with company can exactly know the objects of company and whether the contractual relation with which they intend to enter into with company is within the objects of company or not. Okay, if there is any outsider and he wants to make any contact with the company, from the memorandum he can know whether that contractual relation is within the limits of the company or within the objects of the company or not. Any transaction not within the extent of the powers is ultra vires and void. Okay, if there is any transaction which is beyond that power or beyond the limits, that will be void, it will be useless, and ultra vires, beyond power. Ultra vires means beyond power. So while drafting memorandum of association, utmost care should be taken to ensure that the scope is wide enough to include all activities in which the company may engage. What are the contents of memorandum of association? There are fundamental clauses. These are the name clause, the registered office clause, objects clause, limited liability clause, and capital clause. Let's see name clause. Company being a legal person, it must have a name. It cannot get registered with a name which the central government thinks undesirable. What is undesirable? The name should not contravene Emblem and Names Prevention and Improper Use Act 1950. Okay, nor the name should suggest government's patronage or protection to company. The name should not include the word cooperative. Any non-government company and enterprises are prohibited to use the word national in their names. The name should not be identical or too nearly resemble any other registered company's name. Okay, so this was name clause. Now see registered office clause. Section 12 clause 1 says that the company must have registered office within 30 days of incorporation or on the day of commencement of business or start of business, whichever is earlier. What is the purpose to have registered office? So the registered office will enable persons including registrar dealing with the company to serve notice, documents or communication. Next is objects clause. It is the most important clause. It sets out purpose for which the company is formed and the kinds of activities or business it intends to carry on. So it is mentioned in objects clause. Next is liability, limited liability clause. In section 4, clause 1, subclause D, it is said that in case of company in which liability of members is limited by shares or guarantee, the Memorandum of Association must contain the clause stating that the liability of the member is limited. This statement, this clause should be mentioned in the companies in which the liability of members is limited by shares or guarantees. Even companies exempted from using word limited in their name under section 8 should also state this clause, okay, this statement. What is the effect? The effect is this, that in the event of liquidation, the member cannot be called upon to contribute more than the amount unpaid on the share or more than his guarantee, okay. In the event of liquidation, he cannot be called upon to contribute more than the amount unpaid on his share or more than his guarantee. Next is capital clause. In capital clause, what is stated? Amount of capital with which company proposes to be registered and the value of the shares into which it is divided, okay. In the capital clause, the total amount with which the company is proposes to be registered and the value of shares, value of the shares into which this amount is divided, okay. So this was Memorandum of Association. Next is procedure for alteration of capital clause. This comes under Memorandum of Association. It's an important topic, it comes in exams, so we will include this in this video only. What is the procedure to have alteration, have to make changes in the capital clause? It is given in section 61 that limited company can make following types of alterations by ordinary resolution if authorized by articles to do so. If the articles authorize, then the limited company can make these types of alterations by only our ordinary resolution. What are these types of alteration? Increase in share capital by an issue of new shares, consolidate existing shares into shares of larger denomination. Suppose there are shares like of 5 rupees, there are 10 shares, okay, total amount is 50. If you consolidate them into shares of value rupees 10, then there will be only 5 shares, okay, the amount will be 50 rupees. So these shares are converted into shares of high denomination, or reverse can happen, high denomination can be converted into a smaller amount. This is next point. Subdivide its shares into shares of a smaller amount, or they can convert fully paid shares into stock or vice versa. It means stock into fully paid shares. Or they can make alteration by cancelling unissued shares. The shares which have not been issued, they can be cancelled, and to that extent diminish the amount of its share capital, okay. Such cancellation shall not however be deemed as reduction of share capital. It will not be deemed as a reduction of share capital, okay. Share reduction of share capital requires more formalities to be done, and more, there are more requirements to be done to do reduction in share capital. Next is increase in share capital, okay. How the share capital can be increased? It is given in section 62 that limited company having share capital can increase its share capital by such amounts as it thinks expedient, subject to, it can increase its share capital by any amount it thinks expedient, but these conditions must be satisfied. These are, articles should contain powers authorizing the company to increase its capital, okay. The article should authorize it. The resolution should be passed in the general meeting to increase the share capital, okay. And the notice about the resolution should be given to the registrar within 30 days of resolution, okay. Notice about the resolution should be given to the registrar, then we are increasing the share capital. Next is reduction in share capital. This is most important topic, it most often comes in exams. Section 66 says that subject to confirmation by tribunal. First requirement is reduction in share capital should be confirmed by the tribunal. Next is company limited by shares or guarantee having share capital. Okay, either the company is limited by shares or it is limited by guarantee and having share capital, they may reduce its share capital by passing special resolution. Okay, in alteration it was only ordinary resolution, in reduction it is special resolution. So how they can reduce the share capital? By extinguishing or reducing the liability on share capital not paid up. The unpaid share capital on it, the liability can be reduced or extinguished, or by refunding surplus of the paid up capital. Okay, if there is paid up capital and there is any surplus, by refunding that surplus the share capital can be reduced. By writing off the lost capital, if there is any lost capital, it can be written off. Through this there will be reduction in share capital. Or by any other method approved by court, or is if there is any other method which is approved by court, through that method also we can reduce the share capital. So following conditions must be fulfilled or satisfied when reducing share capital. What are these? That the articles must permit such reduction, there should be special resolution. Okay, and there should be confirmation of the resolution by the tribunal. So we have done memorandum of association, its meaning, its definition, its purpose, its clauses. It means contents like that, fundamental clauses like name clause, registered office clause, objects clause, limited liability clause, share capital clause, all this capital clause. Okay, and then we did the alteration in share capital, increase in share capital, and reduction in share capital. So this was memorandum of association. If you want the PDF for revision, you can get the download link in description or comment box. If you are interested, you can get it from there. Next topic we will do is articles of association in next video.